Welcome once again to Lehto's Law. Here's Steve Lehto.
Remind me to mention the shirt at the end of the video. An Australian lawyer has apologized for an AI-generated filing with the court, and this was in a murder case. So Joseph sent me a note about this, and it's fascinating to me because I've done stories about American lawyers who've gotten in trouble by filing things with courts that they used AI to write, and then it turns out that the stuff was filled with errors and hallucinations. And it's happening everywhere now, including Australia. So Rod McGurk wrote this for the Associated Press. A senior lawyer in Australia has apologized to a judge for filing submissions in a murder case that included fake quotes and non-existent case judgments generated by artificial intelligence. The blunder in the Supreme Court of Victoria is another in a litany of mishaps AI has caused in justice systems around the world. A defense lawyer who holds the prestigious legal title of King's Counsel took full responsibility for filing incorrect information and submissions in the case of a teenager charged with murder, according to court documents. "We are deeply sorry and embarrassed for what occurred," he said, speaking to a court on behalf of the defense team. The AI-generated errors caused a 24-hour delay in resolving a case that the justice had hoped to conclude on Wednesday. The justice ruled on Thursday that the client, who cannot be identified because he's a minor, was not guilty of murder because of mental impairment. At the risk of understatement, the manner in which these events have unfolded is unsatisfactory, the justice said. The ability of the court to rely upon the accuracy of submissions made by counsel is fundamental to the due administration of justice. The fake submissions included fabricated quotes of a speech to the state legislature and non-existent case citations purportedly from the Supreme Court. The errors were discovered by associates of the justice who couldn't find the cases and requested that defense lawyers provide copies. The lawyers then admitted the citations do not exist and that the submission contained fictitious quotes. The lawyers explained that they checked the initial citations and wrongly assumed that the others would also be correct. So they checked some but not all, they say. The submissions were also sent to the prosecutor, but the prosecutor hadn't checked the accuracy of them either. And that's one thing I'm a little disappointed by. When my opposition files a brief and I read it and it's got something in there I don't recognize, I look it up. Now, I'll admit I practice a fairly narrow field of law, so I know the case law in my field. But the judge noted that the Supreme Court released guidelines last year for how lawyers should or should not use AI, saying it is not acceptable for artificial intelligence to be used unless the product of that use is independently and thoroughly verified. Court documents do not identify which system was used by the lawyers. In a comparable case in the United States, a federal judge imposed a $5,000 fine each on two lawyers and a law firm after ChatGPT was blamed for their submission of fictitious legal research in a claim made there. A judge said that they had acted in bad faith, but he credited their apologies and remedial steps taken in explaining why harsher sanctions were not necessary to ensure that they or others won't again let artificial intelligence tools prompt them to produce fake legal history in their arguments. Later that year, more fictitious court rulings invented by AI were cited in legal papers, filed by lawyers in another case where the lawyer then took the blame, saying he didn't realize that the tool he was using for legal research was also capable of hallucinations. So this is happening again also in British High Court, where a justice warned in June that providing false material as if it were genuine could be considered contempt of court, or in a most egregious case, perverting the course of justice, which is actually a crime, a very serious crime. So two things. One is, I said, remind me about the shirt. Thank you. Normally, the shirts I wear don't match the topics. It's usually random. I've got a rack of shirts with 150 shirts on it. I pull them off that side, wear them during a video, and put them over there, and they work their way down. Some days I shoot two videos, one right after the other, okay? Boom, 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 okay? So I actually walked over to the desk, had two stories, and I looked down, and one story has to do with the inevitable takeover by Skynet. So I thought, okay. And I actually changed the order of the two stories. So for once, there is a match between the shirt and the topic. It does not happen often, but it did happen here. Second of all, I've got to remind you, and I talk about this, and I want to make sure it's very, very clear. Some attorneys forget this, but many non-attorneys don't know this. But if you look at the court rules in any jurisdiction, you're going to find a rule similar to this. So in Michigan, the courts follow the Michigan Court Rules, MCR, Michigan Court Rules. Michigan Court Rule 1.109E sub 5. The effect of a signature. The effect of a signature. The signature of a person filing a document, whether or not represented by an attorney, constitutes a certification by the signer. So if I sign a document, I'm an attorney, or a person who's not an attorney and has an attorney signs a document, anybody signing a document and submitting it to the court is certifying that A, he or she has read the document. You cannot sign a document, file it, and when asked by the judge, go, I didn't read it. No, you've already certified that you read it. That's A. B, to the best of his or her knowledge, information, and belief, formed after a reasonable inquiry, the document is well grounded in fact and is warranted by existing law or a good faith argument for the extension, modification, or reversal of existing law. So it's well grounded. So not only did you read it, but you made sure it was well grounded. So if you ask a program to draft you a brief and you read it and then file it, and well, you met sub A, you read the document. B, is it well grounded? No, that's a problem. C, the document is not interposed for any improper purpose, such as to harass or to cause unnecessary delay or needless increase the cost of litigation. That's not as important here. But then you should know that the very next section is sanctions for violation. And this is violating the signature requirements. If a document is signed in violation of this rule, the court, on the motion of a party or on its own initiative, shall impose upon the person who signed it, a represented party or both, an appropriate sanction, which may include an order to pay to the other party or parties the amount of the reasonable expenses incurred because of the filing of the document, including reasonable attorney fees. Now, sadly, the next sentence says the court may not assess punitive damages. I've always thought they should have punitive damages available in an egregious case. But I'm telling you right now that I've mentioned many times, I wouldn't want to be a judge. Don't want to be a judge, never want to be a judge, never will be a judge. However, if you said, Steve, let's say you get to be a judge for one day. Just one day, judge for a day. What's the one type of case you'd love to have in front of you? You know, I would love to have one of these AI-generated hallucination cases in front of me. Because I would love to have an attorney walk up that podium, put their name on the record, and then start asking him questions about how this happened. How did something get filed that you signed that contains hallucinations because you certified that you read the document? When you read the document and there was a case in there that was completely made up, how did you not catch that? You didn't check it, did you? Oh, I'm sorry. Does that mean that you checked to make sure this document was well grounded? Oh, you didn't? Oh. How long have you been a lawyer? How many documents have you signed? I mean, if you said, Steve, take a wild stab at how many documents you have signed and filed with courts, tens of thousands easily? Because I file a complaint, and then I often file witness lists, and I often file briefs, I often file motions, I often file all kinds of stuff on any given case. And yeah, I draft it, I review it, make sure it's well grounded, I sign it, and I file it. Guess how many times in 34 years I've had a judge haul me up the podium or the lectern and start asking me questions about why I signed something? Zero. And it's actually kind of interesting how this is happening now, because these kinds of things so rarely happened in the old days, pre-AI. You didn't have people dragged into court to answer why a brief they filed had made up cases in it. And you'd think that somebody out there in desperation would make up a case. But no, because it's so easy to catch. And once you've done it, you can't say, did I say that out loud? No, you wrote it on a piece of paper and signed it and filed it with the court. You can't take that back. So it's crazy to me that this happens at all. But the fact that it's happened now, pretty much everywhere it seems, and it keeps happening. And I know why it's happening. People look at ChatGPT or the equivalent, look at the product that comes out of it, and they go, wow, that is amazing that they can do that. And it is amazing. Doesn't mean you should sign your name to it and say, yeah, I vouch for this. There's a long way they got to go before you get to that point. And so people look at ChatGPT, et cetera, and say, this thing's doing my job for me. It's going to take care of my entire job. Well, instead of saying I'm going to save this much time, how about this? Say you save this much time, and then use this time here to double check it. Because if you double checked it, you discover, it made up cases. And who doesn't know it makes up cases these days? Seriously, everyone should know this now. There's a reason we're talking about this. Not only is it entertaining on some level, it's quite interesting, but it's the kind of thing where it's like, wow, it happened to somebody else. Make sure it doesn't happen to you. And yet, here we are. So the story's from the Associated Press. Joseph sent it to me. Thanks a lot. Rod McGurk wrote it. Australian lawyer apologizes for AI-generated errors in a murder case. And the judge was not happy. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. The only way to get rid of temptation is to yield to it.